All right, good Friday morning to you, everybody. I'm Nate Eaton here in the EastIdahoNews.com newsroom. We're just going to get this live hearing underway. Let me get this set up here on my phone. We're moments away from Lori Vallow Daybell, set to appear for a pre-trial hearing. A pre-trial conference is what it's called. Now, it's unknown if she actually will be in the courtroom today. A lot of time with pre-trial conferences, the actual defendant does not show up. This is more of a meeting for the attorneys to get in front of the judge and say, here's where we stand on the case, here's what's going on, here's maybe where we can go next. Sometimes plea agreements are worked out, sometimes charges are dropped. I'm not saying that's going to happen in this case, but generally pre-trial conferences are more informal type of settings that happen in courtrooms. And here's what will be discussed today: the 3 felony charges that Lori currently faces in Madison County. And those charges are resisting or obstructing officers, criminal solicitation to commit a crime, and contempt of court. She was charged with 2 felonies in Madison County earlier this year when she was charged with deserting her children. Those charges have been dropped. So currently, she only faces the 3 misdemeanors in Madison County and the 2 felonies in Fremont County. But today's hearing will focus on those 3 misdemeanors. We also know that her attorney, Mark Means, is requesting that bond be lowered from $1 million to a lower amount. He hasn't suggested an amount, but it's likely that that will be discussed today. Now, in a way, a lot of people are saying, why should they lower her bond? $1 million is high enough. Remember that on those charges she has in Fremont County, the 2 charges of the conspiracy to conceal evidence, she has $1 million bond on those charges. The charges in Madison right now, it's only the 3 misdemeanors. Not downplaying that that's not important, but there are 3 misdemeanors. So to have $1 million bond on 3 misdemeanors is high considering other people who face similar crimes. That might add some context as to why he might ask for a lower bond. We also know that Mark Means, her attorney, is talking about moving the trial down the road when it does go to trial, that Lori Vallow is pleading not guilty to the 3 misdemeanors, and that when the time comes, he may request that the trial be moved. He hasn't officially submitted any sort of documentation that, yes, we want to move the trial today, but he is saying that he does want that trial moved. Now, this hearing is set to get underway here in about 1 minute at 10:30 Mountain Time. We have known that in the past, due to technology issues and other situations that come up, sometimes these hearings start a bit later, but it is scheduled for 10:30. And again, this is called a pre-trial conference. This is where Lori's attorney, Mark Means, and Lori herself possibly, along with the prosecutor, Rob Wood, will go before Judge Michelle Mallard, and they will talk about different options about where the 3 misdemeanor charges go from here. This will be held via Zoom, so it's likely that the judge will be in a different place than Lori and her defendant and the prosecutor, kind of like how we've seen the previous trials. Because of COVID-19, it's not like it's going to be a formal hearing inside a courtroom. But one thing we do know is that the preliminary hearing coming up here in August for Lori and Chad will be held in person. They're actually installing plexiglass barriers in the Fremont County Courthouse so that there will be an actual hearing. The judge will be at the bench. Chad will be with his attorney. Madison County Prosecutor Rob Wood will be at his table, and they actually will hold an official hearing. I spoke with a few of the witnesses who have been asked to speak at those hearings coming up in a few weeks. They are getting prepared for what is to come. Chad's hearing will be the first Monday and Tuesday in August. I believe it's the 3rd and 4th. And then Lori's hearing will be the following Monday and Tuesday, the 9th and 10th. So we are just waiting for Judge Mallard to log onto her YouTube channel. I promise that the hearing has not started yet, even though it's supposed to begin at 10:30. We're just going to talk here for a minute. We're monitoring her YouTube channel. Once that channel goes live, we will stream it here for you. I'll step out of the way. You'll be able to see the entire proceeding. So what will happen at today's hearing at this pretrial conference? Well, that's a good question. I mean, it's possible that They could come to some sort of agreement about the charges, that maybe Lori's bond is lowered in regards to the misdemeanors. It's possible that they just set a future court date to take these misdemeanors to trial. It's possible that Mark Means could submit a notice that he wants to move the hearing to another county, as he's mentioned that he wants to request that should a trial come up. And it's possible that other issues could be discussed. But it's important to remember that there's not going to be a lot of discussion today about the felony charges that Lori currently faces, because this pretrial conference deals with the 3 misdemeanors. The misdemeanors: resisting and obstructing officers, criminal solicitation to commit a crime, and contempt of court. Now, there's been a lot of talk lately as to why Lori and Chad... Oh, it looks like we have the hearing now, so let's jump over to Judge Mallard's YouTube channel.
I will note that public access for this hearing is available on Judge Mallard's YouTube channel. That's me at https://coi.isc.idaho.gov. You'll also notice that some of us are wearing masks and some of us are not. I'm in a courtroom alone by myself, so I'm not wearing a mask. Because Ms. Daybell, Mr. Means are sitting at a table together, they are wearing masks. Mr. Means, can you describe for me who else is in the courtroom with you?
I can, Your Honor. Obviously, myself and my client, Mrs. Daybell, and we have 2 deputies from the Madison County Sheriff's Department present as well.
Thank you. Mr. Wood, is anyone else there in the room with you that we can't see inside the frame?
No, Your Honor.
All right. Then today is the date and time set for a pretrial conference, and the purpose of a pretrial conference is to set a jury trial date and other necessary dates. It's also to discuss matters we need to take up to make sure we have an orderly disposition of this case. Since the last hearing, Mr. Wood has dismissed the felony counts relative to this case here in Madison County, remaining, leaving the 3 misdemeanors at issue: count 1, resisting and obstructing; count 2, solicitation of Melanie Gibb to resist and obstruct; and count 3, contempt. Mr. Means has filed a not guilty plea to those charges, a demand for a jury trial, which means we need to set this for a jury trial, and a number of other motions that I will discuss here in a few minutes. So that is all that we are prepared to take up today. As I noted, Mr. Means filed a couple of other motions that may need to be scheduled, one for sure, the others I'm not quite so sure about. But the first thing that I want to go through today is setting the jury trial. Mr. Means, can you tell me how many days you think you will need for a jury trial?
Well, I'd be interested to hear how many days the prosecution thinks as well, but I think we would need to set this for approximately 4 to 5 days for these misdemeanors, just to make sure we're covering our bases. It could potentially be longer. I mean, obviously this case is a little different than most misdemeanor cases. And so there could be some other time issues as far as in preparation for the jury trial that might add a few more days to that number.
All right, Mr. Wood, tell me your view of how many days. And I realize there are other charges outstanding in Fremont County that you are also the prosecutor on. So if you could just let us know what your plans are in regards to this jury trial.
Your Honor, in terms of time, I agree with Mr. Means. Approximately 4 or 5 days would probably suffice. And so, yeah, 4 or 5 days, I think. We probably should just block off a week at some point to do it.
All right. Okay. And Mr. Means, tell me how long you think you need to prepare, how long you'll need between now and the jury trial setting.
I think Probably more than your traditional setting. We have some discovery that's going to come over in the next few days. I understand it's another extensive amount as far as size goes, as gigabytes and information and whatnot. This case obviously is a little different than most. I would be reluctant to say anything within the next 6 months, really. There's a lot of conversations that prosecution and I need to have regarding this. My client is, if I can inform the court, is going to waive her right to a speedy trial on this matter, if that helps with the scheduling as well.
Mr. Wood, your view of how long you need to prepare?
Your Honor, on this case, the state doesn't need that much more time to prepare. However, as to what Mr. Means said, there are conversations between the defense and the state in regards to venue, possible consolidation of cases. And so in and of itself, no, we don't need a lot of time to prepare, but I think what Mr. Means has said is accurate in terms of the conversations we're going to be having in terms of when we actually try this and if it gets consolidated with other charges.
All right. Well, 6 months out takes us into January. Is that what you're thinking, Mr. Wood?
That's fine with the state, Your Honor.
Mr. Means?
It's fine with me, Your Honor.
And I do not have in my courtroom a calendar that extends into January. Madam Clerk, can you let us know what the third and fourth Mondays in January are?
Yes, I will.
If I can, Your Honor, according to my calendar, January 18th of this next year is going to be a federal holiday. So
Okay.
we might be looking at the fourth Monday in January if we want to try.
And what day? What day is that, Mr. Means?
Martin Luther King Day.
Right. Yeah. Thank you for calling that to my attention. But the next Monday, what's the next Monday?
I don't see any conflicting holiday on the 25th.
Okay.
So it'd be the 25th to the 29th.
Okay. Mr. Wood, how does that work for you?
That's fine for the state, Your Honor.
So we'll set the jury trial for January 25th through 29th. Plan on starting at 9 a.m. And right now it's set for Madison County. I understand that Mr. Means has reserved his right to request a change of venue. The next thing that I want to take up is scheduling Mr. Means' motion for a bond reduction. Have the two of you discussed that at all, Mr. Wood?
Yes, and the state is fine if Mr. Means wants to argue that today. We're prepared to argue that. Obviously at the discretion of the court, but we're fine to argue that if he wants to today.
All right, Mr. Means, is that what you'd like to do, is talk about it today?
If that's possible, Your Honor. I don't think a lot has changed since the last two bond hearings we've had. So I think it's pretty short and concise as far as our argument goes on why it should be reduced.
All right. Well, the court was not prepared to take that up today. Let me ask Madam Clerk to put us all in the waiting room for just a minute. Let me take a brief recess. I will get my notes from the last hearing so that we can not have to start from scratch. So we'll be in recess for just 5 minutes, Madam Clerk.
Thank you, Your Honor.
All right, everybody. We're going to get right back to the hearing in just a minute. Don't worry, you're not going to miss anything. We're monitoring it over here on a second screen. Here's what we know. I'm going to lower this mic here. Is that a jury trial has been scheduled for the last week of January for Lori Vallow Daybell on the 3 misdemeanor charges that she's facing. It'll be January 25th through the 29th in Madison County on the charges of resisting or obstructing officers, criminal solicitation to commit a crime, and contempt of court. Right now, the judge asked to go to recess because Mark Means, Lori's attorney, is about to argue for a lower bond on these charges. It was not on the docket today to actually take this up, but Prosecutor Rob Wood said he had no issue with it, and the judge is going to grab her notes from the previous bond hearing from a few months ago that lasted a few hours, where Mark Means really fought to have bond lowered from $1 million, he suggested, down to $200,000, maybe $100,000. Judge Mallard ultimately rejected that request. So it sounds like in just a few minutes here, Mark Means is going to request for another bond reduction for Lori Vallow Daybell on these 3 charges. She also has a $1 million bail on the charges she faces in Fremont County for the conspiracy to conceal evidence in regards to her children's remains that were found on Chad Daybell's property last month. So even if bond should somehow get dropped down to 0 today, which I'm not saying will happen, but if the judge said, you know what, we're not going to set bond at all, she would still have the $1 million bail in Fremont County. So right now they are preparing to take up the issue of bail, and that could go for several minutes, could go for several hours. I guess we'll see what happens there. But the one piece of news that we do have already is that a jury trial has been scheduled for the last week of July, July 25th through the 29th, on the 3 misdemeanor charges. One of the things that Rob Wood, the prosecutor, mentioned is that there is talks between the state, between Mr. Wood and Mark Means' office, to possibly consolidate some cases and possibly work together to get things maybe moving at a more efficient pace, or at least consolidate a bunch of these cases. If that is what happens and will happen over the next few months, then it's likely that come January, this trial may not even be necessary, or there could be additional charges that are filed. So although the jury trial is set for July 25th, it's likely that that could get moved. We're keeping an eye on Judge Mallard's page here in just a minute, so we will go back to that hearing as soon as she comes back in. This is not the first time that Judge Mallard has had Lori Vallow Daybell in her courtroom. Several weeks ago, she appeared with Mark Means, her attorney, to discuss lowering bond. That's back when she was charged with the 2 charges of desertion and non-support of children. Those charges have been dropped. They've been, the charges have been amended. Once she was charged in Madison County with the conspiracy to destroy evidence, Prosecutor Wood amended the original criminal charges, so she currently no longer faces the desertion and non-support of children because, frankly, they know where the children are. And they can't say that she deserted them when they did that. What's that? January. If I said July, I misspoke. The trial would be January 25th through the 29th, not July. That would be the hearing for these 3 misdemeanor charges. It looks like Judge Mallard is not quite there yet, but she should be shortly. Here's what we know will happen after today. The judge could lower her bond today, and Lori could, of course, potentially meet that lower bond, but then she's going to have to meet the bond for her Fremont case if she clearly wants to get out of jail. What's next for her is that in 2 weeks, 3 weeks, I believe, August 9th and 10th, she will go before Judge Edens for a preliminary hearing on the charges she faces in Fremont County, those conspiracy to conceal or destroy evidence. And that's when there will be witnesses called. It's scheduled right now for 2 days of hearings where the prosecutor basically needs to go before the judge and say, this is all of the evidence we have. This is why the case should be elevated to a jury trial. The judge will then decide, yes, there is enough evidence here to have the case move forward, and her case will be moved to district court. It's also possible that the judge says, there's not enough evidence here to take this to a jury trial. I'm not going to send this up to district court, and it remains on the magistrate level. A week before this happens, there's a lot of dates here, a lot of moving parts. Chad Daybell will appear on August 3rd and 4th in Fremont County for the same thing. It's called a preliminary hearing. He'll be there with his attorney. Rob Wood will be there. Judge Edens will preside. And for 2 days, the prosecutor has to prove that there is indeed enough evidence that Chad Daybell did conspire to conceal the evidence and that he actually did conceal the evidence, meaning the bodies of JJ and Tylee, and that when that happened, he will have to convince the judge that this indeed did happen, and then the judge will move it up to the higher court, the district court, and that's when a jury trial will be set for those charges. So that happens with Chad on the 3rd and 4th of August. With Lori, it happens on the 9th and 10th of August, a week later. Rob Wood mentioned moments ago that there's talk of consolidating some cases potentially. That could be one consideration. Maybe they decide to hold the preliminary hearing for both of them at the same time all at once. That would be an interesting turn of events here if that does happen. And we would know before that trial date or that hearing date in August because it would be posted publicly. But that will likely not be discussed today. What's going to be discussed today when Judge Mallard comes back from this recess is Lori Vallow Daybell's bail. She's being held in the Madison County Jail on $1 million. She's been there since March. Originally, bail was set at $5 million in Hawaii. They then extradited her back to Madison County. She went before Judge Edens. He agreed to drop the bail from $5 million to $1 million, and then her attorney asked for a new judge. So Judge Edens was disqualified and Judge Mallard came in. Looks like we're back on.
I think we have everyone back in place. Can you hear me okay, Mr. Means?
We can, Your Honor. Can you hear us okay?
Yes. Mr. Means, since this is your motion, go ahead with your argument.
Okay, thank you, Your Honor. Real short, Your Honor. As set forth in our motion, the change in circumstances here really is regarding the dismissal of the 2 felony counts that were in the previous complaint. We're left with, as the court mentioned earlier, 3 misdemeanors, an obstruction, a solicitation, and a contempt charge, which carries with it a maximum, according to my calculations, 2 years and possible $2,500 fine. The only thing I would add, in addition to the things that have been argued in the previous 2 bond hearings, is my client has been a model inmate. These charges are not of a violent nature. There is no previous criminal record regarding my client in any other jurisdiction that we're aware of. Her access to funds is extremely limited. I think the court has issued an order previously outlining that if my client were bailed out or bonded out, that there were certain restrictions in place that we're fine with keeping those restrictions. We think ultimately that the $1 million bond isn't reflective of the current charges, that we'd ask that the court reduce it to $100,000.
Mr. Wood?
Thank you, Your Honor. We do acknowledge that at this time, the defendant faces misdemeanor charges in Madison County. We also acknowledge that she's also being held on a $1 million bail in Fremont County. We would point out that each of these misdemeanors were, in the state's view, an overt act of in furtherance of a felony to conceal the location of the defendant's minor children, Tylee Ryan and JJ Vallow, who are deceased. In terms of the factors in Rule 46, I'll just focus on what we see has changed from the last time we argued this in front of Judge Edens and in front of yourself. And I think where it's really changed, well, one is her familial, any family contact she might have. Her only family contact is Chad Daybell, who is a co-defendant in the Fremont County case. And in our view, her only family contact now is someone with whom her legal interests are completely adverse. In terms of aggravating factors, I think that's where the real change has occurred. There are many aggravating factors. I'd point out that, Your Honor, the last time we had a discussion of bail in this case, we were arguing about jail phone calls while the defendant's children were dead. And the state finds that very troubling. And so I just point out, Your Honor, that when the defendant obstructed the investigation into the safety and welfare of J.J. Vallow, she was hiding the location of her dead child. When she attempted to get Melanie Gibb to lie to the police on her behalf, she was attempting to get Miss Gibb to lie about the location of her dead child. And when she refused to comply with a lawful order to produce her children, she did so in an effort to conceal the deaths of her minor children, all while telling family and friends that they were fine. And so, Your Honor, those aggravating factors that bear on the likelihood of conviction are troubling, they're strong, and quite frankly, they also bear on the defendant's character, which the court is allowed to consider in a bail reduction hearing. Acknowledging these charges are misdemeanors, if the court is so inclined to lower bail, we'd ask that it be no lower than $250,000, and we would ask that all the current restrictions on bail and for release remain in place.
All right, thank you. Anything in response, Mr. Means?
Just briefly, Your Honor, obviously the court is well aware that the client is innocent until proven otherwise. I think some of the argument that has been put forward to justify a $250,000 bail is based on, though out of respect for the argument, speculation that requires a certain amount of jumping from point to point in order to justify. Again, we just ask that the court consider the dismissal of the felony charges, which were previously the bulk of the potential incarceration time. Here we're looking at 3 misdemeanors, and I think $100,000 is more than appropriate in this setting.
All right, thank you.
Thank you, Your Honor.
There are 2 procedural matters in this case that are inescapable. One is that these are misdemeanors with a total maximum sentence of 2 years if they're run consecutive to each other and if Ms. Daybell is convicted. The second procedural matter that impacts my decision is that there is another pending case in Fremont County in case number CR 22-20-838, a conspiracy case. Again, there's conspiracy case against Ms. Daybell. And that case has a $1 million bond. So regardless of what I do with bond here today, there's still another case with a $1 million bond that is outstanding. I'll note that Ms. Daybell was taken into custody in February of 2020. So she's served at least 5 months by now, which if she were convicted would go as credit to her sentence. I've previously noted that the factors that I consider are those stated in Idaho Code Section 19-2904 and Idaho Criminal Rule 46C. We really are not going to have any trouble, I don't think, ensuring the appearance of the defendant no matter what bond I set, considering the bond in the Fremont County case. Bond is present. She does have the right to bond, and I will set bail today and will lower it. A third prong is ensuring the protection of victims and witnesses, and the fourth is ensuring public safety. I cannot overlook Idaho Criminal Rule 46C, subsection 6, which is the nature of the current charge, which I've already taken into account. They're misdemeanors with a relatively low maximum sentence. But also that prong requires me to take into account any mitigating or aggravating factors that may bear on the likelihood of conviction and the possible penalty. Of course, in our system of justice, Ms. Daybell is considered innocent until proven guilty, but every court in Idaho, in consideration of what bond should be set, is allowed to consider the likelihood of conviction and any mitigating or aggravating factors that may bear on that likelihood. I think it's inescapable that these misdemeanor charges are relating to the whereabouts of her minor children who have now been found deceased. All of the other factors are really no different than where they were when we had this last hearing. I am going to reduce bond based on my consideration of all those factors. I'm going to set bond at $50,000 on each count for a total of $150,000 in bond. If Ms. Daybell does post bond, I'm adding an additional condition to her release that she have no contact whatsoever with her alleged co-conspirators. In the Fremont County case number CR 22-20-838. Do you have any questions or clarifications about my decision, Mr. Means?
I do not, Your Honor.
Mr. Wood?
No, thank you, Your Honor.
All right, the court will prepare the amended order regarding conditions. Mr. Wood, would you prepare the order regarding the reduction in bond?
Yes.
All right, I'll anticipate seeing that in the next couple of days. Anything else we need to take up at this pretrial conference, Mr. Means?
I don't think so.
Mr. Wood, anything else we need to take up?
No, thank you, Your Honor.
I'll remind both attorneys to pay close attention to the pretrial order I will issue within the next day or two. It will have the required deadlines, and you will be expected to either meet those deadlines or to ask for leave to depart from those deadlines. We'll be in recess.
Thank you, Your Honor.
Thank you.